Hi, how are you? It is Ellen Wright, owner of Wright Family Law Group. Today I'm going to walk you through Rule 410 in the Massachusetts Probate and Family Court, what it is, how it works, what you need to know about it, and everything in between. All right, Rule 410 is a supplemental rule in the Massachusetts Probate and Family Court that has to do with mandatory self-disclosures. So, if you are a party to a divorce, all right, as soon as the service of process is made, that means when the complaint is served upon the defendant in the action, right off the bat, both parties have to exchange some important things. That is federal and state tax returns, 3 years, your 4 most recent pay stubs, information that you have through your job about the nature and availability of health insurance. You will also need to produce 3 years worth of bank statements. That's individual and any bank accounts you might have joint. That might be with your spouse or a family member. 3 years worth of retirement stock or other asset accounts, brokerage accounts, that kind of thing. You're going to need 3 years of that. Mortgage applications. If you filled out any applications to refinance a mortgage or get a new mortgage within the past 3 years, we need copies of those. Less common, but maybe you've done it if you filled out a financial statement or a balance sheet. Maybe it was done by your accountant for maybe a business that you might have had. We need copies of those as well. Now, this is a checklist that is on my website. If you go to the Wright Family Law Group website, if you go up to the top here, I'll just go back to the home page and walk you through. If you're over here in the resources tab, go down to online forms and then scroll past the intake forms and you're going to go down here and you will click the Rule 410 required document checklist. That will take you to this form that we use to sort of notate what we have and what we need and what we're missing. Now, if you are in a situation where maybe you weren't responsible for filing the taxes in your house and you don't have access to the taxes, maybe they were filed but you don't have copies of them, that's okay. If you don't have them available, you're just going to need to notate that on your checklist to specify that you don't have them, and maybe just write a note about where they are or why you don't have them. That's helpful to know. And if you tried to get them, what efforts you took to try to get them. Now, I will tell you that Rule 410 is pretty comprehensive. If you want to read the rule, you can do that. If you are very studious and you want to learn about the law, that Rule 410 information is on the Massachusetts Trial Court website. It's all right here, and you can read through it at your leisure. But to summarize it in a nutshell, if you're in a divorce, all of this has to be disclosed right off the bat. Do people do it? You have 45 days from the service of process to do it. People don't always do it. Usually it's done after a formal request goes out in writing, but that technically is not the rule. This is what people do, but it really should be collected and exchanged early on in the case. Now, if you are not involved in a divorce, if it's a paternity action, so if the parents weren't married to each other, there is mandatory Rule 410 exchange, but it's abbreviated. So the initial disclosures, if you're in a paternity action, so you weren't married in your situation, the child was born out of wedlock, the mandatory initial disclosures are the state and federal tax returns, your 4 most recent pay stubs, and information about the health insurance. Those are initial and it's required. Now, in those situations, there are the bank statements, the brokerage statements, the mortgage applications, and the statement of assets and liabilities. Those are additional. So those, you're only required to produce those if it's requested in writing. Okay? So that is sort of the rule summarized in a nutshell. But it's really important early on in your case to work on collecting this paperwork, because what happens is from a lawyer's perspective, we have to look at it and see what's going on with the finances, where money is going, in order to make a determination if additional discovery needs to be done. If we need to request additional documents, or we need to sort of send out requests for information that require more information from the other side to be produced. So we can't, it's hard to do that until 410 is dealt with and it is done. So, again, use this checklist as your guide. If you are a client of ours and you're confused about this, or you're overwhelmed, or you can't really figure out maybe what to do, or you need some help and some coaching and some guidance on how to do this, reach out to the paralegal assigned to your case, and we will be happy to guide you through. I hope this video was helpful, and good luck in your divorce or your 209C paternity proceeding. Take care.